Yes, I can.
All right. You've heard me talking to Miss Brower, who is also present from the Kent County Prosecutor's Office. I don't have what she is saying. She wants to amend this to seek a uniform child support order as opposed to a paternity complaint. I have read Mr. Rodriguez admits, he says that, he signed an AOP, he's working, he provides and all this kind of stuff. All right. And so you just want to be able to ask for a uniform child support order. Is that?
No, Your Honor. What I'm requesting, our office filed a complaint for paternity. However, these parties had already signed an affidavit of parentage. So what I'm asking is for the court to grant me permission to amend the complaint for paternity and to file a complaint for support instead, because that's what should have been filed.
All right. Ms. Sorensen, do you have any problem with that? I mean, because they could just dismiss the case and refile, okay, quite frankly. And there's nothing I could do about it. All they're asking is that they refile a support complaint.
I don't mind if they do the support thing.
Mr. Rodriguez, I mean, it's really kind of almost clerical type of thing, because if I denied it, they would just dismiss it, refile it as a totally different claim and move on from there. Do you have any problem with them just amending the complaint and not making a paternity complaint, but a child support? I'm not ordering any child support or anything at this point. Ms. Brower will be in touch with you and all that kind of stuff.
Okay.
No problem with it then? No objection?
No.
All right,
No.
I'll grant it. You can send it over via DocuSign and then go through the normal steps as it relates to child support. I'm sure that the state has some vested interest in this because there must be some state assistance.
Yeah.
Even if it's Medicaid or whatever. Ms. Brower is going to send out a thing. You do a pre-hearing conference with them, don't you?
I had a pre-hearing conference, Your Honor. At this point, after the complaint is amended, I'm just going to file a motion for entry of judgment.
All right, make sure that they just get all that information, look it over. We'll be back here at 2 to 4 weeks from now and see about the possibility. You can contact Ms. Brower if you have to and talk to her about it. Let's just get this done. Okay.
Your Honor, can I ask you a quick question? Can you please tell me the name of the document that you did get, just for training purposes? I know that you said you didn't get the motion.
I don't have. The only document I got is the notice of hearing with remote participation.
Okay.
And in that, it says in the first paragraph to establish child support.
Okay. All right. I'm going to look into that. I appreciate you telling me that. And thank you so much for granting today's motion.
All right. Well, thank you to the parents. We just got to get to an end to this and we will get there. Good luck, everybody. Thank you very much for
Thank you.
present today.
Thank you.
I can barely hear you. What is
Oh, no.
There, I can hear you now.
Better? Okay.
I can hear you just fine now. Okay. We'll start with Bolks v. Bicot.
Okay.
All right. Both parties are present on Zoom. Sir, I'm not sure I pronounced your last name. I'm sure I kind of butchered it, but
It's Bicot.
Bicot, okay. And Miss Bolks, both of you can hear me?
Yes.
This is both parties are present. Ms. Smith-Lowe from the prosecutor's office is present. This is a motion to enter a judgment of paternity, I believe.
Yes, Your Honor.
The USCO uniform child support order. Father also has a motion that he is seeking custody. Obviously, I can't even deal with that until a paternity order is even entered. I can't do it because you're not even the father until I sign an order that says you are the father. So is there anything you wish to say, Ms. Smith-Lowe? It's apparent that that he is the father.
Yes, Your Honor. Miss, I'm covering this for APA Yasmin Dahan.
Yes.
And she's had a number of conversations with the parties since the complaint has been filed. And her last conversation with the parties is based upon what the court has in its possession, which is the judgment of support. Judgment of paternity, and UCO requesting support. This Ms. Bolks is in Texas. The calculation is based upon an imputation for her of $11 an hour, 35 hours a week. Actual income of Mr. Bacot at $17.25 hours a week at 30 hours. $17.25 at 30 hours a week. Miss Bolks has the child residing with her primarily. 365 overnights, no overnights for Mr. Bacot. The effective date would be June 1st, 2024, and we're asking for reimbursement of the genetic test costs. Your Honor, we would ask, I know that there's been a lot of back and forth with the family. We would ask that I believe that Ms. DeHaan has also filed an order of reference if the court is inclined to do that, and enter our judgment on a temporary basis. But we're asking for entry of the judgment of paternity as proposed with and the judgment and the UCSO.
Right. The only question that I would really have is, you do have in your standard order that she has physical custody. I know the child is living with her, and she's apparently moved to Texas when did you move to Texas, ma'am?
I want to say August 16th.
So just recently.
Yes.
Was it after this was going? After you knew this was going?
No, it was before.
Okay. And I'm kind of reluctant to just, this case was filed on May 15.
Yes.
So you clearly moved after this case was filed.
I didn't hear about it.
So, and I'm reluctant to. I will, sir. You want to say anything at this point?
Me, myself,
Yes, sir.
I would like to be able to see my child. I would like to have some custody for my child. The motion states that I don't mind that she moved to Texas, but being that she filed and then moved to Texas, I would like that if I do get custody, that she would be responsible for transportation for the child to my custody. Well,
this is going to be difficult, obviously, because you live so far apart. Nobody's going to get 50-50, especially when the kid starts to school. He can't go to school half the time here and half the time there. I think signing a judgment of paternity is appropriate for your sake, for everybody's sake, because that opens up the case as to what we're going to do as far as parenting time and stuff. Ma'am, we're going to have to figure something out about parenting time. Sir, you call it custody, but the chances are she's going to have physical custody, but you might want to have joint legal, but we got to deal with all those issues.
Your Honor, just so that the record is clear, I do want to state on the record that Miss Bolks and the child appeared for genetic testing on July 24, 2024.
Okay, so you obviously knew this was going on before you moved to Texas.
I knew about the DNA, but I didn't know that he was motioning for custody.
Well, but I'm saying you knew this was all up in the air. You say you didn't know anything about it, and you knew about it. You took the child for testing and stuff, so you knew about it. Maybe the best thing to do is to refer this to the friend of the court for parenting time, child support, or not. We'll enter the child support order right now as well, because that's got to protect the state some. And what we'll do is send it over to the friend of the court for them to look at custody, both physical and legal, and parenting time, even though the real issue they're going to have to deal with is parenting time. We're going to figure something out, because he's got to be able to see his child as much as possible. How old is the child?
She'll be 1 on the 18th.
Yeah, I mean, we're gonna have to figure something out so that he gets some parenting time. So we'll refer this to the friend of the court they're gonna contact both of you. They gotta know your address, because otherwise they will do an investigation based only on the other person's stuff, okay? And it won't come back good for the one who doesn't cooperate. So, make sure the Kent County friend of the court has your information. We'll enter the 2 orders. That gets you into the ball game, sir.
Thank you, Your Honor.
Otherwise you're still in the dugout and can't get in, okay? So
Yes, sir.
I'll sign these orders when they're sent over by DocuSign. We'll get them going. You'll get copies of it. It would behoove both of you probably to try and figure out something. Because otherwise it's gonna be up to me or the friend of the court to figure out something. She's gonna have to have some time with father. And it's gonna be, right now, I know she's not in school, but when she's in school, it's gonna be a lot of the summer and spring break and Christmas break and stuff like that. Why don't you guys work on something? If you don't, I'll have to do it, all right?
Yes, sir.
All right. Good luck, everybody. Ms. Smith-Lowe, if you'll send over the orders, I'll sign them.
Assuming you want the uniform child support order to be entered on a temporary basis, or?
Yes, yeah,
Okay.
yeah, all right,
Okay,
because
sure.
I don't know what'll change with anything, okay?
If anything, okay, thank you.
All right, good luck, everybody.
Thank you, Your Honor.
We'll waive the fees. I'm gonna waive the friend of the court fees, otherwise each of you has to pay $150 towards it. And this will be a one-time, Christmas present for you. I'll waive it.
Thank you, Your Honor.
Thank you. Good luck.
We have that on
Thank
our
you.
order of reference, Your Honor. I'll send that over as
Okay,
well.
thank you.
I already have it done.
We already have it done, Michelle, if you,
Oh, do you?
Yeah.
Okay, okay.
On it.
she's very efficient, at least this early. As we get later in the morning, she's not gonna
She starts to
prepare.
fade.
It's gonna get worse as we get there.
Fabulous.
Yeah.
I don't believe that.
Bias versus Sims, both parties are present along with prosecutor Miss Michelle Smith-Lowe. This is a date and time asked to enter a judgment of paternity as well as a child support order. My understanding is the father acknowledges that this child, there are 2 of them, I believe, are his children and has not asked for DNA. So that should be easy to enter that one. There's also the necessity to enter a uniform child support order. Both parties have actual income, and he was also given credit apparently for, well, both of them for an additional child in the calculations. Does that pretty much ask what you want, Miss Smith-Lowe?
It is, Your Honor.
Miss Bias, any statements you want to make?
Pertaining to,
Entry of these orders, do you object to them?
no,
All right, Mr. Sims? Do you have any objection to these entry of these orders?
They got my pay wrong.
What is your pay rate?
28.83, not 29.04.
I doubt that's gonna make any difference, but Miss
83.
28.80.
2883. That's 20 cents an hour, basically less.
Oh, of course, my computer is.
Why don't we do this? Ms. Smith-Lowe, when you're done with all these motions, you can recalculate it based on 2883 times 40 hours, and that'll be used. It will make very, very minor modification, if at all, to it, but we'll make sure it's correct. And I'll sign that order. All right. I don't know what the child support order is right now. What it calls for.
Your Honor, I can tell you in just a minute. 2883. Same amount of hours.
40 hours, yes.
40 hours. 2883. 2883. I just want to make sure that I'm putting in the right numbers. And we will have the result in 2 clicks. And that would be, 854. Changes by $4.
All right, child support will be not 858, it'll be 854. We have that correct, and when you send those documents to me, I will sign them. You'll get copies of them, both of you, in the near future. I'll sign them and we'll get a copy out to both of you, okay? Anything else? All right, hearing nothing else, thank you both very much. Take care, have a good day. We're adjourned.
Yes,
Thank you, Your Honor.
The Howell v. White, this is a guardianship case, in which the prosecutor is seeking child support, entry of a support order from Cassie White. The calculations are actual income from Cassie of $15.61 for 25 hours. I'm not sure why we're limiting to 25 hours, but for right now, that's all right.
Your Honor, Miss White indicated that she's working part-time because of childcare issues.
Right.
She might have other children in her care.
All right. Well, I say I'm not gonna, normally I'd require a lot more hours, but under the circumstances, we do not take into account Ms. Howell's income because this is a guardianship case. It's $230 that would be owed by Cassie to Rika. Rika, do you have any comments about entry of this order? Do you agree with it?
I don't have any comments.
All right, thank you. Cassie, do you have any comments about this order?
Nope.
All right, then, hearing no objections or whatever, we'll enter the order as soon as it is sent over to me via DocuSign. All right, thank you to both of you. Thank you very much for your cooperation. We are adjourned. Thank you.
Thank you.
7-1 DP, Brown v. Williams. Ms. Brown is present. We also have the prosecutor, Ms. Michelle Smith-Lowe, present. Mr. Williams has not logged in. This was scheduled for 8:30 and it's 8:59 right now. He's never logged in. He's not in the courtroom at all. So we will proceed with it. There is a request to enter a judgment of paternity as well as a uniform child support order. It does appear that paternity has been shown to be 99.9+%. And it does appear, I've got that report, that he is the father of the child Esmare. And so I think, do you have any objection to that, Miss Brown, that he is the father?
Yeah, I don't have any objection.
All right. Then next we will proceed to the uniform child support order. Mother has actual earnings of $14 an hour times 40 hours. The prosecutor has gone through a number of factors here to determine $14 an hour for the father is an appropriate amount. I don't actually have, yes, I do. I have the imputation factors for Mr. Williams. He's 39 years old, has previous but sporadic work experience with Workbox. You don't know a lot other than that about him. Don't know what his education is. He apparently has not cooperated with you much. Is that fair, Ms. Smith-Lowe?
That is correct, Your Honor. I did give him an adjustment for 3 other children, and he has no overnights.
And he has no overnights.
It's unable to reach him for the pre-hearing conference.
All right. The only thing I would be reluctant on is, are you all right with him being imputed with only 35 hours as opposed to 40 hours a week, ma'am? Or do you want that recalculated that he would?
Yeah, that's fine.
All right. Then you don't object to the uniform child support order, which makes him responsible for child support in the amount of looks like he's supposed to be paying almost $300 a month for that, $289 a month. You have no objection to the entry of this order?
Yeah, no objection.
All right. Thank you very much. Then we will enter both the judgment of paternity and the uniform child support order.
Thank you, Your
Okay,
Honor.
I have a question.
Yes, ma'am.
I'm not, I mean, in the future, I will allow overnights, but, as far as that goes, do I have the right to say no to overnights?
There's nothing in the order about parenting time at this point.
Okay, okay,
Okay.
thank you. Yep.
Quite frankly, there just isn't. He may have to come in, but to ask for it, there's nothing that gives him any specific overnights. You can agree or not agree. He can always make a motion to the court. I can tell you that he'll get parenting time with his child, and I hope you work with him. But at this point, there's nothing other than the two of you making an agreement on what the time would be.
Okay,
Be wise about it, because I'm telling you, if he comes in front of me, I'm gonna start giving him parenting time.
right.
Because he's now, has a paternity order and we know he's the father, so. All right,
Okay.
thank you very much.
Thank
Good
you.
luck. Take
Yep.
care. Thank you. We're adjourned. Thank you. Smith, no one's here on this one. Little by little, the Smith lawyer wearing them out. They started all showing up, and little by now, they're just tired of it.
That's right.
You know that you're a force to be reckoned with.
With, yes.
It's Gonzalez versus Smith. This was set for 8:30. On Zoom, it is now 9:03 and no one has appeared. This is relating to two children. The father, I guess I understand why he isn't here. It appears that he may be in prison. Is that your understanding?
Your Honor, he's in the Newaygo County Jail. And so we're asking to reserve support until such time as he's able to pay support this, but we also are asking for entry of the judgment of paternity.
Well, is there a paternity test or anything?
There is no paternity test. He did not. We were going to default him. We could have defaulted him. He did, because he didn't answer. Excuse me.
Bless you.
Oh, goodness. But rather than, yeah, I've been fighting this for 5 weeks now. But rather than default him, we set this for a hearing.
Oh, now you can imagine my only concern here is I hate to default somebody to be a dad when
I do.
Is there some way we can get him tested, especially while he's in the Newaygo County Jail?
I can give him another opportunity to ask. I can send him something to see if he wants genetic testing, yes or no. And if we get that back, then and if I don't get that back, I can motion again. If I get it back and he wants it, I can test him. And if he doesn't want it, then I can again motion again.
I would like to do that. I know it's more work for you and I hate to do that, but quite frankly, it's not gonna affect his child support because he's in jail anyhow, okay? I don't know how long he's in there for. If we can see if if he's just not gonna answer us, then he'll be defaulted, but
Okay.
quite frankly, if you could do that, I would appreciate it. I'd much rather know that he's the father before defaulting him.
I will do that, Your Honor.
Have you had any contact with Miss Smith?
I was not able to, no, because of the default, we just scheduled this for a hearing.
Okay, because I'm wondering if you talked to her, if she, could provide any information or something. Yes, he's definitely the father, and I'll talk to him about becoming the dad or something like that.
It was not a multiple man case, but I agree with the court to take every measure that we can to protect his rights.
Yeah. Thank you very much. I appreciate it.
Right. I will do that.
All right. I think I'm done with you today. Thank you very much.
All right. Thank you.
Hope you get over the 5 week, whatever it is you've had.
I know, me too. This is getting older just doesn't help things.
Oh, tell me about it. You have no idea. Take care. Have a great weekend.
You too. Thank you. Bye-bye.
Bye.
Thanks, Tracy.
Yep, have a good weekend.
Mr. Grabill, are you there? And if so, I need you to turn on your camera and turn off the mute. Does it show he's connected? You got to unmute. Mr. Grabill.
Can you hear me now?
Yes, I can.
Okay, I'm so sorry. I don't know why it was.
That's right. We got to figure it out. Ms. Butcher, can you hear me all right?
Yes.
All right, we're here in the parties present by Zoom. This is the motion filed by the mother for various reliefs, if you will. I've read your motion. I read your responses, sir. There are several requests. First request being made by the plaintiff is that I order the kids not to refer to their new stepmom as either mom or mama. That's in effect what you've asked. So just so I understand, you want me to order the kids not to do that, and then if they do it, you want me to hold them in contempt and maybe fine them or lock the kids up for doing it? Is that what you want, ma'am?
No, I just was requesting this because I feel it blurs the boundaries and I feel
I'm saying, you want me to order the kids not to do that?
no, I just wanted it to be ordered for her not to be called that because they
But
are
it's the kids who call her. It's the kids who say it. So if the kids call her that, what do you want me to do?
I understand, but they are telling the kids to call her that and they're confused by it. So I just feel like it's
Kids
inappropriate.
they have two moms. They have a mom and they have a stepmom right now. And I'm not gonna get into what is appropriate in there. I mean, it's micromanaging. Let the kids be kids. They're only 6, 5, and 2, aren't they?
Yes, Your Honor.
Yeah.
It doesn't sound like you're very have much self thought about you're afraid the kids are gonna see her as the mom or something like that. The kids are growing up, they'll know you're the mom. I'm not gonna tell them, as long as they don't call somebody derogatory names, I don't care what they do. Because I'm not gonna hold the kids in contempt for calling her that.
Right. I understand that.
All right, so I'm gonna deny that motion. You got one here that you want to exchange some about the holidays because you got week on, week off. Well, I'm not gonna be modifying an order. You mean you don't want to exchange for Christmas or whatever else is in here according to the holiday schedule? Is that what you're asking for?
Yes, Your Honor. Ryan and I agreed just to keep the schedule the same, just week on, week off and not go back and forth during the holidays.
Okay, so I guess I don't need to do anything because you guys agreed to it. You guys can do whatever, you guys can do whatever you want on holidays. I mean, you need a court order saying what? Eliminate all holidays in the schedule?
No, Your Honor, I do not want that. I want that to reflect because unfortunately, she goes back and forth. So I would like to keep at least that effective and then we can do our own thing if we choose to.
You guys can always do your own thing if you can agree to it, but other than that, the court order has what is going to happen in there. So if it is violated, if he violates it and doesn't give you the kids on Memorial Day because it's your Memorial Day, but it's his week and holidays always trump regular parenting time for both of you. So we'll keep that in there. If you can work stuff out, you can work stuff out. Third request is child support. Ma'am, you say something because there are no more childcare expenses.
Right. So I didn't know. So now I have a significant amount of childcare expenses and I didn't add it on the last review. They're now in
But it
daycare.
says right in the last order that each party is responsible for their own childcare. That was it. It's right in the order. That's when it happened. You had week on, week off, and there was all these, and each party was just going to be responsible, whether you have a nanny, whether you go to tutor time, whatever you do, that was in the order. Why would I change that?
I guess I was just confused if we added all the expenses that we're giving. I understand that we're providing our own and then he didn't send in the review, so he was needing to add in the that
There's
he's
no childcare expenses in the last review in there at all. Because both of you, I don't care how much you spend, I don't care how little you spend, I don't care if you use relatives, I don't care. When you've got the children, you provide it. When he's got the children, he provides it. If it costs him nothing or if it costs him $1,000 a week, I don't care. Because you got 50-50 and you guys can figure out who does the daycare of these kids when you got them. That was just the last order. It says, I can find it.
That was on April 19th. I think May 2nd was entered. I put it in as an exhibit for you, Your Honor.
Well, I'm trying to find it in the file, but the last, looks like the last UCO was like $402. You each have 50-50. No child care expenses from either party were added into it because the order says each party is just responsible for their own child care. And that's the way it should be. You got 50-50, figure out who pays for whoever what, because there were complaints before about that, and it was just, so, that's denied. Dental care. She has to have information on dental care.
You're right, Your Honor, and I have given that to her because she had it for the original dentistry that we've utilized. My obviously work does not offer a card on the dental program, and she knows that. We've always had to
What
call
do
a
you
number.
offer then? I mean, what happens when you go into a dentist? You just say, trust me, I got insurance?
No, there's a number that you have to call that they get your number. They don't give us a physical card, and that's what she requested. And I told her we don't have that. I've given her the number that she can call to get the dental number.
You have that number, ma'am?
No, I don't.
All right, then just so we're positive, you can either email it to her or something so you have a record of it. Does he have your email address?
Yes.
All right, email it to her today. You say she has it, but if she says she doesn't, it's fine.
Yeah.
Email it to her today so you've got a record of it, sending it to her. You will get that number today. All right, and if it changes or anything to that, you have to let her know immediately. All right? That seems to take care of that one, because she is entitled to that. As far as the cancellation of an appointment and stuff, I don't know what you want me to do about that. It's from February. So I just want to make sure you have the dental insurance information. You don't have dental insurance, is that correct, ma'am?
Right. He provides the dental.
All right. So, yeah, I mean, if for some reason you became employed and you got insurance and stuff like that, you'd provide the same information to him. We want the kids covered, I mean, as much as we can, all right, through insurance, but you will provide that to her today via email. Is that correct, sir?
Yeah, I can do that, Your Honor. I do have one question.
Well, does it pertain to this issue?
Yeah, insurance. Yes, it does. With the last FOC calculation, I did not get credit for providing health insurance and dental insurance. Is that something I'm obligated to do if she has a job that offers that, or I'm just out of curiosity?
I don't know what your order says. And I quite
Okay.
can't go back through it and find everything, read your.
That's fine, Your Honor.
Divorce and or child support. We want quite frankly, if you have it, do you have the ability to have insurance for the kids, ma'am?
What did you say, Your Honor? I'm sorry, I didn't
You
hear.
have employment that has insurance for the kids?
I have employment, yes, but he was supposed to provide the health care and dental for them.
Okay, well, be aware that there's gonna be stuff that isn't covered.
Right.
And I don't know why you wouldn't also include it, because if you can have secondary insurance, but if it's in the order that he has to provide it, I don't know, I just can't find it. And I've got a lot of hearings today, all right? If you want to bring it up at a later time, fine, then I can do it. But if he's to provide it, he is providing it. Just give her the information that is necessary so she can use the insurance, okay? Final issue, wants only the parent with the parenting time to attend school activities. Is that about it, ma'am? Is that what you say?
Yes, Your Honor.
Why do you want me to penalize the kids?
Well, I feel whenever it's my parenting time and him and Sarah show up to events, they take off with the kids. Ryan makes rude comments to me. I just feel it's not in the best interest. I'm just
Really want to penalize the kids and not have, so that when the kids have another thing, you can't go to it and you can't see them if they're playing, I don't know what they're in, if they're in T-ball or they're in a kids play at the elementary school and he has them, you don't want to even show up for that. Is that right?
It's just too complicated. I feel like it's conflict.
It's not too complicated. This is two freaking adults who got to get along in that respect. Sir, if you are making rude comments or anything there, I will see to it that you won't go to those. All right? This is fair warning. If you are doing the same thing, ma'am, I will make sure that you do not appear. I was a divorced parent. I was able to figure out how I could go. My son played hockey and both parents went to the hockey games all the time. We didn't sit next to each other, but we didn't make comments to each other. The son finished playing hockey. If I had him or if she had him, he went over and talked to the other one, hugged him and this kind of stuff, and went with the other person. Come on. For God's sakes, really? I'm yelling at both of you. I don't even know if either of you is at fault or if both of you are. That's just a penalty to the kids.
Mhm.
The kids want their parents there. I'm going to deny that until I find anything specific. If I find anything specific, you're both fairly warned as to what I'll do. All right? Work for these kids. You got 3 kids and the youngest one's like 2, for gosh sakes. You're going to have them forever. Good luck, everybody. Thank you.
Thank you, Your Honor.
Thank you,
Adjourned.
Your Honor.
ES, it's Lee versus Boorsma. Both parties are present via Zoom. This is a motion by the defendant father regarding transportation. Basically, he says he would like to, each party would be responsible for the child to pick up. He says he does all the transportation. Mother's response says they've been meeting at Schaefer and 28th Street at Qdoba, or she'd be happy meeting at 28th and Kalamazoo at Myers. Sir, what's your response to this? Well, either you have a remarkable ability to not move a muscle or you are frozen.
Can you hear me, sir?
Yes, I can. Can you hear me?
Yes, I did. Both locations she would like to are both a half a mile away from her house. They're nowhere near halfway.
Well, where? Okay, they're how far do you live apart?
I'm on Ionia, right down the street from you right now. I live on Ionia Street.
Right.
I'd like to simplify it by just splitting it even, that way. Because most of the time when I go to pick up my daughter, she's not there. She's not there. She's got every excuse in the world. So
That's
I'm
when you
left
file
sitting
a
in
friend
a
of the
bucket.
court violation. If she's not there, you file a violation with the friend of the court. They'll investigate it. If it's proven to be a problem, then I'll deal with it.
Sir, she's been charged with contempt for this matter.
I believe, how long ago was that?
Oh, 8 years ago, 7 years ago.
It was, I have in my notes, she was charged with contempt 8 years ago. All right. She knows what'll happen if she doesn't do it. Pick a spot that's somewhere in between Ionia and 28th Street. She says she doesn't really feel comfortable with you at the house. Okay. So where do you want to pick a spot? Do you want to pick a police department somewhere or whatever?
28th Street and 131 should be right in the middle.
Where, and I know where that is. What location there?
Why not out in front of Rogers Plaza?
Ma'am?
Yes.
All right.
Are you asking if I'm agreeing to that location?
Yeah, because I'm probably going to order something like that halfway between. Just meet. I wanted a public place. I wanted some place where, you know what? Well, it's
Right.
28th Street. The Wyoming Police Department's right around there. You want to meet at the Wyoming Police Department?
Where is that located?
28th and DeHoop is what it is. It's just a little bit west of 28th and 131. And then you can meet in it's where the courthouse is and for the Wyoming District Courthouse. Then if anybody tries anything, you got cameras, you got police, you got everything around there. You say you're afraid of them, so I'm trying to make it as best I can for you.
Right, no, and I appreciate that. Yeah, we are a little bit more east. We're at near the 36 and East Beltline. So I just figured, 28th and Kalamazoo, right at that Meyer gas station or the Meyer grocery store is about the halfway meeting point. So like I said, we've met at that gas station before. I figured that was fair. Right by the highway, that's even closer to him. I mean, I'm trying to work with him.
Well, I
meet
am
him
too,
halfway.
but quite frankly, my first thought was to make it an exchange. Can you stop smoking? And you're in court.
Yes, sir.
Like drinking and
Yes, sir.
stuff like that. Act like you're in court, please.
Yes,
all right? Sir. My first thought was to go to a police department. I just didn't know which police department was the best one to do. If you're at 28th and Kalamazoo, you're not very far from the police department for the Wyoming Police Department. All right.
Right. I think the closest police department is the Kentwood one right there from Walma.
Oh, that's way out. That's
but that's right. That's further away from him. So
yeah. So meet at the Wyoming Police Department. Then nobody can screw around with somebody else. That, the chances are also that if somebody doesn't show up, you can probably go into the police department and say, hey, I'm here right now. I just like you to sign this that says I'm here and, she's not, or he's not. We're just trying to figure it out. It's not exactly a long ways from 28th and Kalamazoo to the police department. In his house. All right.
Right.
So, we'll do the Wyoming Police Department for exchanges.
Okay, so am I able to say anything to the opposite party?
It doesn't sound like you guys get along very much, but what are you trying to say?
Well, I guess I was
just. Why don't you
just,
say it to me and I'll decide if it should go to him. What is it you want?
I just trying to see if he can, be reasonable meeting halfway, because that's about 15-minute drive for us, which is, a lot shorter drive for him. So
he's on Ione down here. It's a good 10 minutes or more drive for him.
It's right in the middle, sir.
I know where everything is. Okay.
Yeah.
And yeah, it's about a 15-minute. And if he's on Ionia down here, if the expressway is open and has no problems, it'll take him 10 minutes at least to get to the Wyoming Police Department. All right. If you guys want to eventually work on something else, but half of this is for your request because you don't feel comfortable. And I'm trying to.
Hey, I'd have brought my daughter home to her. She wouldn't even have to leave the house.
I'm going to order the Wyoming Police Department at this time for all exchanges.
Yes, sir.
Okay.
All right. Good luck. We'll send out the order. Thank you.
Thank you.
All right.
I understand I could get comments on YouTube when I say number 9. 20. Moleg versus Moleg. Ma'am, can you hear me all right?
Yes, sir.
The former Mrs. Moleg, we're waiting for Mr. to connect. I don't know what he's burning on there. It looks like a golf cart or something like that. Must not have had the best score of the day. And it doesn't it look like it might be a scorecard from golf? It does. Yeah. Ma'am, if you just mute, I'm gonna take another one here while we try and get him to connect.
All right. Thank you.
And then we'll call you back, okay?
Thank you.
What was that?
Thank you.
You're welcome. What was that? This is a matter, 25 PM. See if you can kind of control that background noise. It's a matter of Cartagena Torres. Well, I see why it's difficult, but versus Mr. Castillo. The plaintiff is present on Zoom. The defendant has never been present. Did you notify him of this? It says you sent him a copy of this on the night, and on the 16th of September. Is that correct? You sent him a notice of it?
Yeah, correct. This is the second hearing that he was for the first hearing he was.
Okay. This is your request for a ROPA hearing, if you will. You have provided a DNA test that Mr. Castillo is not the father. Has Mr. Moleg logged in? Sir?
He's not.
All right. And you have provided that he is 99 point, that this looks like Oliver Montegro is the father of the child. I'm assuming that's probably the child you got on the video right there.
Yes.
Hello. Has Mr. Castillo ever had a relationship with that child?
No.
Has he even met the child?
No, he has not met the child.
And if I make the child born out of wedlock, is it your intent that Mr. Montegro is going to file something? You're going to do an affidavit of parentage or something?
We have the affidavit of parentage, and he is on the birth certificate.
All right.
Yeah.
All right. Well, under the circumstances and from the testimony, that everything you've told me is true, isn't it? About the fact that the father is Montegro.
Yes, correct.
All right. And that the one that you're in the divorce with is not. So it does appear that the child, which I can't remember the name of the child. Can you tell me right now?
Olean.
Okay. Is born out of wedlock. It does not appear in your divorce that there are any other minor children born or adopted during this relationship. Is that correct?
Correct.
Okay. So we will have your child that is born out of wedlock designated that. You can make that child the issue of Mr. Montegro. We will change your divorce from a DM to a DO, which is a divorce without children. Okay. So you can take all steps to get that completed now. Okay.
Okay. So I just fill out the package of the DO.
Yeah, it's going to be a DO now, because once we get this through, we're going to ask it to be changed to a DO. Okay. Because you don't have children. All right.
Am I able to start filing those papers now at the legal assistant center? Or do I have to wait?
Yeah, give me a couple days to make sure we get the order through. Okay.
Okay.
All right.
All right.
If you come down right now, I'm on the bench and we aren't going to get an order, and we're going to get it to you as quick as we can. But sometime next week, you should be able to do it. Okay.
Okay.
It'll take the clerk's office a while and things like that to make sure that it is, but we will get the order through there. Okay.
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 All
Good
right.
luck. Thank you.
Thank you. Okay. Bye.
All right, Mr. Moleg, can you hear me now? Yeah, that's good, except you're on mute. So I heard you say, I saw you say yes, but you didn't come through. Can you unmute? You're trying.
Okay, how about there?
All right, now I hear you. That was not a bad, must have been a bad golf score you had on your, that shows up as your
Seen that, eh?
Yes.
That wasn't me really, but go ahead.
All right. Hope you didn't give up golf because of that. This is a case Moleg versus Moleg. Both parties are present via Zoom. This is mother's child support motion, although you don't make any request for relief, ma'am. I don't even know what it is. You said you got a letter of 8/16/24 that your son was turning 18. They were going to stop child support. I don't know. You're also saying that he got the full amount of Social Security benefits and wants to know when the son gets half of them. I don't know. It's not up to the court. If it's not in the judgment of divorce, it's out there. I don't even know what you're asking. If it's in the judgment of divorce, then it has to be handled. If it's not, then it's not. And you're asking about the last year's review for child support, and you said you don't know why the fee didn't go down. I'm assuming you're talking about why the child support didn't go down. You didn't object to anything that was done by it. You were given a notice on 11/30/2023 that there was not enough change in child support to warrant going through that, and that if you didn't like it, you had to object. You didn't object. What are you asking for now?
Well, my child support, I'm still paying through my employer. It says on the back of the sheet that you sent me that the
I
child
sent you?
or the court sent me a letter stating that his support would be finished on August 16th since he turned 18. If you flip the letter over on the back, it says that the child has to meet all 4 requirements. He does not meet all 4 requirements. So my question is, why am I still paying?
I don't know why you're paying. What is your, Mr. Moleg, what is your response?
Why is she still paying child support
Yeah,
after he's 18?
yeah.
Because he's still in high school.
Attending full time?
Correct.
And nothing has changed? Both of you still have 50-50?
Correct.
Nothing has changed, ma'am.
It says on the back of this paper that he must reside full time with the person receiving support.
But it's absolutely no change in circumstance from before. He resides 50% of the time with you and 50% of the time with dad.
Correct.
So child support will continue until he is finishes high school or 19 and a half, whichever. Is he going to finish this year?
Yes. In May.
In May? Yeah. Then everything will continue in effect until, because there's nothing that's changed. The purpose of it is to make sure that they stop at 18 or when they finish high school, whichever is later, but at no time can it go beyond 19 and a half. Your son is still attending school just like he was. He's in high school. He's expecting to graduate. He's going full time. That's why you're still paying.
Okay.
All right. So everything else, I think I've kind of addressed. Anything else you want to say, ma'am?
Not one bit.
All right. Anything from you, sir?
No, thank you.
All right. Thank you, everybody. I don't even know that I'm denying a motion because it's just a request. So, but I'll deny this. Thank you. We're adjourned. DM Drager versus Drager. We have the defendant, Mr. Drager, with his attorney, Mr. Swears. We have Ms. Coletti representing the plaintiff. This is father's motion to obtain a passport for the child who's 11 years old. And I can think of absolutely no reason why we wouldn't obtain a passport for a child in case somewhere down the road somebody wants to travel with him. It's not a request to go anywhere, and make sure that you understand that. Right, Mr. Swears? I mean,
yes, Your Honor.
Can't the 2 of you attorneys just agree to get a passport and one of you can hold it for the time being? I don't care. Whatever it is. It's not to be used for foreign travel at this point, unless the parties can agree that it can be taken, or until they come to me and ask for it. You certainly can't have any objection to that, Ms. Coletti.
Well, Your Honor, I thought we could mediate the whole issue of getting the passport and travel.
Well, let's get passports take a while to get. Okay, get the passport. You're not going to get it tomorrow. I guarantee you. Okay.
I believe it takes only 6 to 8 weeks.
Okay, so what? So you get the passport, and then you guys can figure out the rest of it, because I'm not authorizing out of country travel. Okay, and if you and Mr. Swears want to agree that either one of you can hold the passport until further order of the court.
I did request in my response that Ms. Drager be able to hold the passport.
I'm going to ask one of the attorneys to hold it, because I don't want that to be a problem. Okay.
Okay.
We're happy to hold it in our office, Your Honor, until agreed or further order of the court.
And he would not turn it over under any circumstance unless ordered to do so. Let's just get the passport, and then you guys can fight later, and I'll probably see you later on whether or not there's something to go on or not. I mean, I just, geez, oh, Pete's kid got a chance to get some world experience. Great. So we'll have the passport. Mr. Swear's office will hold it. Mr. Drager, you will not be allowed to use it unless I've given an order to Mr. Swears. If you go to Mr. Swears and say, you're not on the case anymore or something, then Mr. Swears, you're obligated to contact Ms. Coletti and say, he doesn't want me to have it anymore, and it'll go to Ms. Coletti until further notice. All right?
Understood. Understood, Your Honor.
Nothing, I don't imagine there's any problem with that. Correct, Ms. Coletti? And then you guys mediate or figure out what you want to do with travel.
I think Mr. Schwartz and I will be able to work this out. So thank you, Your Honor, for your.
I do too. I think you're both great at this. So I think you'll be able to figure something out. All right. Do I need to issue an order that he can get it on his own, or is the mother going to cooperate right now based on what I've just said to get it?
She will cooperate. Of course she will.
If she does not cooperate within the next week or something to sign the appropriate stuff, then the court will issue the order that he may obtain it on his own. All right. Send it through somebody who wants to draft this order, because I've ordered that Mr. Swears hold on to it.
I'll draft the order, Your Honor.
All right. Mr. Swears will draft the order and send it through Ms. Coletti. Come on. All right. Good luck.
Very good. Thank you.
Thank you.
Thank you, Your Honor.
Take care. Have a good weekend.
Thank you.
We're gonna come back to your next case because I don't see the plaintiff logged in yet.
Okay, thank you.
Yeah.
She has two of them? Each.
I'm just gonna.
You can do whatever you want.
You want to put him back in the breakout room?
DM, both parties
Okay,
are present with the respective attorneys. Miss Brian is here for Miss Ludwig, Miss Van Tol for Mr. Ludwig. This is the mother plaintiff's motion. Basically, it's all around school enrollment, legal custody, all these kind of things. I've read the motion, I've read the response. It's your motion. Miss Brian, do you want to say anything?
Yes, I'd like to just also to give you an update. The one thing that was not clear in the response from Mr. Ludwig is that the child was in or is in tutor time. That's correct. He only was attending tutor time 2 days a week. And then I've learned as of yesterday that tutor time has terminated its pre-K program. And unfortunately, this little guy who's 5 years old was in a classroom of 3-year-olds yesterday. And what they've indicated is that they're no longer going to do any pre-kindergarten or preschool program through tutor time. I acknowledge that there is a program called Great Start that's there, but they've been having problems getting teachers. The whole issue with regard to this particular company that's offering these services is that they're having a terrible turnover with their teachers, and crew has had 15 different teachers in the last 3 months. The parents frequently receive emails where they're asked to volunteer to keep their kids at home or to find other care. And this is obviously not the best situation for a child who should be in preschool right now. As I've indicated in our motion, my client had reserved a spot for him at Ada Elementary Preschool. She has paid for that. She continues to pay for it. She's willing to pay for it. I hear that when the parties first selected the tutor time entity to provide the the preschool and the daycare, at that time, Mr. Ludwig was working for Dematic, which is about a mile away. He continues to work at Dematic a mile away. So this is not an issue so much about proximity. I understand that Mr. Ludwig is worried that somehow if we put the child in Ada preschool, that there's going to be some kind of advantage with regard to the ultimate decision. I mean, Your Honor, I mean, we're at the point where the situation is quite dire, with a child not being in any educational facility right now for preschool. And we could transfer him to Ada preschool. He could attend class on Monday, and this could all be done so that we are facilitating some type of preschool education for him. I know that the courts are backed up. It's not going to be easy to get a hearing, we could do it on an interim basis without prejudice, just to get him into a solid program. I don't think there's any question that this is a solid program. But my client's the one that's been taking the lead on this. She's been working with him since summer, trying to convince him to get him into a preschool program. He's offered basically no alternatives other than the one we've received.
Can I just interrupt you for a minute because I know what you're saying. Ms. Van Tol, are you opposed to even putting him there on an interim basis if tutor time does not have that available? We got to get him in, and they're saying you can get him into Ada and without prejudice. I'm going to have a Lombardo hearing on this at some time, one way or another, whether it relates to preschool, but clearly as it relates to school. Good thing you started now because we can start scheduling it sooner rather than later. Is there any problem with, I mean, do you understand that is not available right now at tutor time? We need, and quite frankly, they've offered to get him in without prejudice to using it when they come in and say, hey, wait a minute, he's going to this school, so he should continue on.
Thank you, Your Honor. I appreciate the court's allowing me to respond to that. What Ms. Bryan is indicating is that they're not offering the preschool program, but they are offering Great Start Readiness program at tutor time. In fact, Crew's teacher is the teacher of the Great Start Readiness program. So what ended up happening is that teacher moved into Great Start Readiness program, and that is a school offered at tutor time where the kids that Crew has been going to school with. So I think the most appropriate thing would be to allow Crew to continue to go to tutor time where he's been going and do the Great Start Readiness program with the teacher he has been with and the friends he has been with. So that is our proposal.
Is it being offered there, Ms. Bryan, the Great Start Readiness program?
I know that the Great Start Readiness program is being offered through tutor time, but the problem with this is that even though it's being offered, they continue to cancel these classrooms. They continue to they've sent an email just the other day, I think, to both parents saying, I know that 2 more teachers have left. They've continued to delay the start of that preschool program because they can't get qualified teachers. And this whole thing about, he's going to be with the same teacher. I'm not convinced that that's true because he's had 15 teachers. So when he says it's the same teacher, is it number 15? Is it number 13? Is it number 10? What number is it? And how long is that teacher going to be? I want to know
if the Great Start Readiness program, is he in it, and is he in it today? Is he in it on Monday?
He's not, because there hasn't been an agreement, Your Honor. So obviously neither party wants to violate the court's order, right? So the issue is he's able to go to that program. It's in the tutor time building.
Is it a regular 5-day-a-week kind of thing?
It is, yes. And the attendance is not mandatory. As both parties have indicated, this child is very advanced, right? He's gifted. He knows his letters.
He be in kindergarten.
He's very smart, right? So the issue is ultimately, my client doesn't want to move him more than once, right? So the purpose of keeping him at tutor time was to allow him to continue with the teacher he knows, who is moving into the Great Start Readiness program, with the friends he still has been going to school with, who are also transitioning into that program.
When is the Great Start program starting?
It started 2 days ago, I believe.
And is an everyday thing?
It is if they want to. They are not mandatory to go. So what happens is Ada Elementary has like 5 days, 2.5 hours. That's their program. So basically the parties would have to drop the child off and pick the child up before lunch. That's obviously pretty disruptive to both. But that's really what is being proposed by opposing counsel with respect to the Ada program. The Great Start Readiness program is 5 days, full days, but you do not have to send them. So the attendance is not mandatory. So the parties have, as they have historically done, have kept Crew so that they can do fun things with him during the day. Obviously, as the child gets older, we're not going to be able to do that. The parties enjoy spending time with their child. That's important for them. And that's historically what they've done, even while he's been in this tutor time preschool daycare program.
And the problem here is that the child doesn't want to go to tutor time. He doesn't want to stay there all day long. He's 5 years old. They have a mandatory nap time in the afternoon. He doesn't want to do it. He begs these parties not to go to tutor time. And Dad knows that. The other concern that my client has is that mom's going to be taking the child to a regimented program, and dad apparently sounds like he just wants to have him home with him and not even put him in school because we continue to hear that attendance is not mandatory. Well, guess what? Attendance is mandatory when you go to school. So why don't we have him in this regular program, which is a regular preschool program, a half day, 5 days a week, and let them get in with the superior program. And I think what Mr. Ludwig is worried about, it's not an issue about, whether, there's not an issue really as to the programs, the superiority of that. I think everybody on this Zoom call knows that the ADA program is superior. We all know that. And this other comment about how
don't tell me that they deny that it's superior.
Well, I guess they'll have to show that then when they examine the number of teachers that pass through. And it sounds as though Dad says, let's put them in Great Start, but I don't plan to have them be there. I mean, I did consider an idea of, if we did Great Start, that there would be mandatory attendance, at least from the parties, of doing, 9 a.m. to noon, just so that he's part of a regular curriculum. But our concern here is that Dad really doesn't intend to take him to preschool on his days and not allow him to receive that education. And if we were doing the ADA program, there would be an attendance chart. Obviously, I don't think it's disruptive to my client, to pick him up in the middle of the day. And Mr. Ludwig continues to boast about his flexibility with his job and how he works remotely. So why can't he or his wife go over in the middle of the day to pick him up? So we're not willing to do the Great Start.
This is a Lombardo hearing all over the place, and I don't move a kid until I have the hearing. And the kid goes to tutor time and will be involved in that program. If the parties screw it up for their own sake and don't send them, you can come back in, because if I'm finding that the kid is not involved with, or if tutor time does not have that program, I'm not going to let them say, hey, next week we don't have a teacher and this kind of stuff. I am going to move them to ADA if that stuff happens, until I get to a Lombardo hearing. What else can I do? I got two people saying this one's no good and that one's no good, and who they're going to do this and who's going to do that. I can tell you one thing, that there's a request for sole legal custody. I found at the last hearing that there was proper cause or change of circumstance to have that hearing. That was a year ago. I found it. And all this does is reinforce that. They can't even agree on the kids' preschooling stuff.
Your Honor,
they can't agree on anything.
They have not disagreed on anything. They've agreed on everything leading up to this in terms of legal custody. They've never disputed a doctor, a dentist.
Because the kid's been going to school, or they've been going to a doctor and a dentist. Nobody's asked to change them. Doesn't mean these parties have been in front of me so much because they can't even agree on a preschool program to get the kid into. They both say he's really smart and but both of them are going to screw around with it. They can't agree on it. And the kid's only 5. I mean, whoever sits here as the referee is going to be doing this 13 years because they can't agree on anything. I mean, are you telling me they've been in front of me because the child was molested? Maybe he wasn't molested. We keep a kid away, even though we don't know if he actually did it or not. And he can't play video games because he shouldn't. But I mean, what more? I don't have many cases that is this contentious.
Your Honor, I do understand. I think a lot of it is related to just normal parenting decisions that both parties feel like they should be.
I don't see a case like this very often where I'm constantly having to do this stuff. I mean, I can go through all the stuff in here that, like I say, video games, contacts with the perpetrator, mom degrading his new wife and stuff like this. We got custody fights. We got hiring a private investigator, holding on to all the evidence that he has in his house as far as videos and all this. It's just one thing after another.
That's why we tried the co-parenting counseling, because the hope was that we
You
would
tried
underlying.
years of co-parenting. Didn't we have Miss Judd on this before this?
We did, and really, like I said,
It
if
was
I thought that-
unsuccessful. And
if I
now we
thought
have somebody who I've got somebody saying, wait a minute, he didn't attend the last time with Amy Van Gunst, and he goes on and gets a document saying I've attended them all and stuff like this. They can't even agree on that. Now, I do believe, Miss Bryan, did you ask for a guardian at one time?
I did.
You
Yeah.
did?
Yes.
I'm more tempted to go back to that now.
I think that would probably be the most appropriate under the circumstances. What we really want is a solution.
We still want to
the
proceed with our
underlying
motion.
problem, which I don't think a grant of legal custody resolves the underlying issues, because none of that addresses legal custody. Obviously, these parties have a dispute regarding school. My client's going to be in the Hudsonville School District. She's going to be in the Ada School District. My client's suggesting, let's not move him potentially twice. I don't want to have him readjust potentially.
I gotta have a Lombardo hearing.
I do understand
End of
that.
story. You can argue all that back and forth. I'm going to have a Lombardo hearing on this. And I guess we will start out, the child, as I say, remains where the child is until there's a change. All right? That's what happens in those hearings. I don't make a change and then say maybe change them back. That's what's gonna happen. We'll get you in as soon as we can. We might as well, counsel, I'm gonna have a status conference with you somewhere along the line to figure out, because we're really gonna argue two separate things, which is both preschool, if you will, and where is appropriate to go to school. We want to get that done. We won't be done with that argument till who knows when, but it'd be nice if parents knew where the child was going to be enrolled. All right. And as far as, okay, like I say, they've had co-parenting counseling for years, and I still see them constantly. All right. It's not working. You may say it is working, but I don't know who thinks it's working. Do either council think that the co-parenting's been very effective? Because from my standpoint, it hasn't.
Your Honor,
one reason why it's not been particularly effective is that Mr. Ludwig just takes the position, I'm not going to discuss something any further. And that's what
my point. That's my point. It doesn't matter. I'm not assigning blame to either party. All right. They just don't work together. They just, he says she's stalking him and, hiring private, I think it was her that's supposed, and he's just bothered by, he doesn't like anything about her and she doesn't like anything about him. It's going nowhere. Nowhere.
Your Honor, will we have two separate hearings? Will we have the Lombardo hearing first and then the motion on our sole legal custody request?
Yeah.
There's a motion regarding physical as well, I think, Your Honor.
If he's going to proceed with it, we could do the physical custody and the legal custody in one hearing.
We're going to do the Lombardo hearing first. And if we can incorporate both the preschool and the school of enrollment, right. I'll try and get you in sooner for that than I am legal custody. Okay. And again, I'm to the point where I'm quite convinced that I'm going to appoint a guardian ad litem, even if it's on my own, because it is not working between these parties. It does not work. I don't care. I can't believe you're even arguing that it does work between these parties. It just doesn't.
Your Honor,
I don't see many people like this all the time.
I guess the point was, I'm not suggesting that it is working. I'm suggesting that the problems that they have are not legal custody issues. They are just.
You can argue that at the legal custody hearing, yes. Okay? Yeah. And there's nothing at the legal custody hearing that says your client or Ms. Bryant's client is going to get it. I don't know who's going to get it. I'm not saying no. Only one person may get legal custody, and if I find not, then we'll keep it joint. It may stay joint. I don't know. Right? There's so many things going on between it. I have contacted Miss Van Dyken to see if she would accept being a guardian on this. I believe she will. If she does, I'm going to appoint her as a guardian. There'll be probably a minimum of $2,000 from each client as a retainer for it. I will have my clerk contact you to make sure that she can do it. All right. my clerk had contacted her and asked, because I asked if, and she apparently was able to, but I don't have a firm thing yet, okay? And if it's not going to be her or something, I will get to both of you and maybe talk about a different person or something. But I gotta have somebody in there who's gonna do some, I mean, that person could probably tell me an awful lot about tutor time and what's going on and what isn't.
Mhm.
You know, because I got two different people saying two different things, but there's only one thing going on. And if I had Miss Van Dyken right now, I'm sure she would have contacted and gone through tutor time and gone through the Ada school and seen what is probably best. Now, I understand that the guardian helps me, all right? I'm still gonna make these decisions. I'm not gonna turn them over to her unless you guys agree to. You know, I mean, in her work with you, and you say, okay, well, you know, yeah, you say this or that, we'll do that. That's fine. But I understand just because she tells me, even if she tells me you gotta have sole legal custody to one parent or another, I'm gonna have the hearing. She's not gonna dictate what I'm gonna do. She'll advise, but she's not going to dictate. I hope you understand what I'm saying.
Yes.
I
Your
do,
Honor,
Your Honor.
is it an appointment of an attorney,
No.
guardian ad litem, or a guardian ad litem?
Guardian.
Okay.
Not an
And
attorney.
should the order reflect that the parties will equally share that cost?
They're each gonna have, probably, I think my understanding, we're probably each gonna have to, yes, you're gonna equally share the cost, but I think each of you is gonna put $2,000 down to begin with.
Right.
Understood.
So I'll be happy to
Oops, wait
prepare that order, Your Honor.
a minute, you broke up. I
didn't
think you
either.
volunteered to do all my orders for the day. But I didn't hear it for sure because you broke up.
I did.
And now you're
Oh,
smiling.
I'm sorry. I said I will be happy to prepare that order.
All of my orders for today. Thank you. That's what I heard. We'll email you all the other stuff that's gotta be done, okay?
Please do.
Sounds great.
Yeah, as long as you do that order and run it through Miss Van Tol, let's get it in
Right.
soon. I will make sure that my clerk lets you know for sure if it is Miss Van Dyken,
Okay.
right?
Very
I
good.
think it is, but I didn't have a confirmation. All right?
Thank you so much.
Good luck,
Thank you.
everybody.
Have a
We'll
great
set
day.
up we'll be in touch with the attorney's office for the Lombardo hearing first.
Perfect.
All
Very
right?
good. Thank
Good luck.
you.
Thank you. Take care. Have a good weekend.
You too.
Thank you. Bye-bye.
Because I know she has it on by the time. All right. Ma'am, you have to pull over. You cannot be driving and be on Zoom.
Okay, sir.
Piso versus Piso. That's I did at the time. We have both parties present on Zoom, and we also have Mr. Kirkhoff representing the defendant, Mr. Heisel. We're waiting for the plaintiff to pull over because I'm not going to do Zoom hearings while somebody is driving. Can you tell if there was an ex parte entered in this case? I've got a motion asking for it, but I don't have any order in the file one way or another from 9/16. Oops, well, I don't know if you pulled over or not. You're frozen, so it doesn't look like you're moving, but ma'am, I don't know if you can hear us or not now because you're frozen or you're gone or whatever.
I can hear you.
Are you parked or what?
I am, yes, Your Honor. I am parked.
All right. I've already introduced the case. As I said, both parties are here, one with their respective attorney. This is mother's request for supervised and or suspended parenting time for the father. There was apparently, and I just had my clerk printed off, there was on 9/16, Judge Hillary entered an order granting extended parenting time of the children to the mother. Mother says that dad hit and bruised Amelia. That's basically it, and she wants to have supervised parenting time. Ma'am, as, you said you referred it to CPS, do you have any CPS reports? Needless to say, I read your answer and he just denies that he did anything to this child. So, ma'am, what's happening with CPS, police, anything like that?
Yes, so on that Sunday night, so it was 3 weeks ago this Sunday night, Grand Rapids Police Department came to my apartment and took a statement. That following Monday morning, CPS called me, and then that afternoon, a caseworker came to my apartment, interviewed me. They had been and interviewed Amelia at school. I don't know on Roberto's side where that stands. When I talked to my caseworker last week with CPS, she had no updates for me.
So there is no substantiation through CPS at this point? There's no criminal charges filed, even though this happened like over a month ago?
It was 3 weeks ago, and yes, that is correct.
I guess it was 3 weeks ago. All right. I mean, how long do you think I need something from CPS or police ultimately. I don't have any verification of anything at this point. You know that.
Sure. And I have my caseworker's name. I don't know what else you need from me.
I don't call caseworkers and stuff like
Sure.
that.
Okay.
I mean, I'm sure Mr. Kirkhoff is going to say, hey, there's nothing been filed against him. There's nothing to even substantiate that he even hit the child and this kind of stuff. And he wants the ex parte order removed. Am I clairvoyant or am I not, Mr. Kirkhoff?
You are correct. I spoke with the detective from Grand Rapids, and she basically said nothing's going to be done on this. Mr. Piso tried to call the CPS people. The CPS people returned his call and said, we will have somebody call you if we need to talk to you. That was 2.5 weeks ago. Nobody has called, nothing. There is absolutely nothing to support this. I had a fairly extensive answer that I put in for the motion regarding parenting time, and it included the fact they got along incredibly well until just recently when Mr. Piso found a girlfriend, and all of a sudden everything has gone horribly well or wrong since then. There is absolutely nothing to substantiate that happened. As I said, I talked to the detective, and the detective normally, as typical, says, well, I can't tell you it's being dropped or anything like that, but yeah, we're not going to be doing anything on this.
No criminal charges have been filed.
Absolutely none. The CPS worker that she supposedly has a name for has never called Mr. Piso back after he's called. And the thing of it is, we've never been served. Mr. Piso's never been served with anything. She denies parenting time and says, oh, there's an ex parte order. Did she file?
Well, there is one, and I can tell you that no matter what, there is an order, okay? That, however, had happened, she does have extended parenting time, and I don't,
the only reason that we even know anything about this is we went to the clerk's office to look. She hasn't served him with a motion that we're here on today, the ex parte order, the ex parte motion, absolutely nothing. So we're kind of going in the dark here. And then she's saying, well, we got the CPS people, and the CPS people, when they do an investigation, as the court is aware, if there's something there, they're going to contact the other party. He has not been contacted except to say, we'll call you if we need you, and nothing has been done. So this is all.
Stop. I understand.
Okay.
So what do you expect me to do when there's no criminal charges, there's no CPS? It has been 3 weeks. It's not like, and what do you expect me to do? Stop him based on nothing for how long?
I can't answer that because apparently I have no grounds. I mean, I have all of the paperwork. Unfortunately, I don't have it right here and I can't send it to you, but
no, it doesn't matter if you have paperwork.
Okay.
It matters that I'm sitting here, I don't know what happened. Okay, I obviously don't know it at all. And all I'm doing is the judge gave you the chance because the possibility was there. And he gave you the chance to do an investigation, the police, the CPS. I don't know. If I don't have any substantiation, I can't just go on, whatever. And if you gave me a CPS report that says we're substantiating him for physical abuse, as it's clear that I'd be dealing with it in a different manner, but I don't have anything. All right, I don't. If the police submitted a request for a warrant to the prosecutor's office, they issued a warrant for child abuse in whatever degree. I'd have something. In fact, if that was the case, they would arraign him and they would say he was to have no contact, period, and you wouldn't even need the ex parte order because he wouldn't be allowed contact. I know the criminal law system also, and so I'm not saying anything bad to you other than I don't have anything to continue the ex parte order, and it's been 3 weeks. If you want to call CPS and get it going again, you can renew this motion and that's fine. But until then, I just don't have anything.
Understood.
So I'm going to have to set aside the ex parte order. Parenting time will start up again. Sir, you better watch out what you're doing.
We would like makeup. Yeah, we would like makeup parenting.
No, I'm not going to give makeup time because it was the judge ordered it. The judge ordered the extended parenting time. I'm not going to give it. It's not that you missed very much. You didn't miss 6 months worth and stuff like that. So parenting time will resume. I don't know when it resumes. I don't even know what it resumes to.
We'd like it to resume this weekend then.
Well, is that supposed to be his weekend?
No, it is not.
All right, then it'll resume next weekend. I'm not going to start everything all different, okay? It'll resume next weekend. Ma'am, if in the meantime you think you got something that's of proof, submit it to, and renotice your motion. But until then, I'm revoking the ex parte order and parenting time is to resume as previously set. Mr. Kirkhoff, if you would please draft that order.
I will do so, and I'll have it to you within an hour.
All right. Good luck, everybody. Thank you. We're adjourned. Is our last one? That would be something. Actually making pretty good progress. Does nobody here needs a interpreter?
Yeah, me.
You need an interpreter?
Yeah.
You didn't ask for one and we don't have one available.
Oh.
So you better contact the courts, renotice it. You're gonna have to set this for a couple. You got to contact the courts and get an interpreter.
Oh, that's cool.
So we're gonna have to set this off for a couple weeks. 2 weeks. It's gonna be adjourned for 2 weeks to get an interpreter.
All right.
Thank you. Can we just set up an interpreter? Because I don't know how much he understands. Yeah. Welcome back, Miss Coletti.
Thank you. Good to be back.
Welcome, Miss Smulders. Haven't seen you for a long time.
I know. It's been a while. How are you?
You come back from the Caribbean after your 3-month or 3-year stay down there and are back.
3-year stay. Yes. Well, I was still back and forth, but yes, 3 years.
Your client is not here.
I know. I'm not certain what's going on. So just a quick second of background. I was retained pretty late last evening, and he knew about this. I've called and I've texted because we had another PPO hearing in front of Judge Hillary. He also did not appear for that. I would respectfully request for an adjournment for today's purposes. not necessarily, I mean, obviously because my client's here, but also because I was very much retained late. I do note, though, that if the court wants to schedule this motion for an evidentiary hearing or a custody investigation through FOC or something like that, I wouldn't object to that and wouldn't request an adjournment for today's. But if there is any specific request or relief requested from Ms. Coletti, that would be the grounds for my objection, Your Honor. Or
All right. Well, all that having been said, I'll introduce the case.
Okay.
DM. No, I was just finding out when you got back from the Caribbean, and then all of a sudden, the next thing I knew, this is the matter of Hiler versus Mendoza. Just so you know, Ms. Smulders, I just had these parties in front of me Tuesday on his objection to a PPO and found that it was appropriate. And apparently, I don't know what happened with was that for a PPO violation that in front of Judge Hillary?
This morning was, yes.
Can I ask what the result was?
He did not appear, so a bench warrant was issued.
Okay. All right, and this is a motion by the mother through Ms. Coletti for sole legal, physical, and to modify parenting time. I can say that from the pleadings, and Ms. Smulders, you've kind of already said some of this, that from the pleadings, I do find, even if for nothing else than the domestic violence issue, there is proper cause or change of circumstance clearly to look at both physical and legal custody is a factor in the best interest, and it certainly performs the proper cause part as well as others that may be related to it. I mean, there's problems with afternoon parenting time and all this kind of stuff that he has that he's apparently not exercising, I think, because he says he works now and can't do it. I listened to him on the PPO go on and on about how he has Thursday nights, and I've read over and he does not have Thursday nights, and that he's keeping the child on Thursday nights, all these kind of things. Clearly, there is proper cause or change of circumstance to have a Vidvarka. She's met Vidvarka, and as a result, I clearly have to have an evidentiary hearing on that. All right. And so Ms. Smulders, you said you wouldn't object to something like that. I can't change custody here.
Correct. Yeah. I had already informed my client that I believe they've met the burden and that would be the next step. So he is aware.
My question to both of you, and I don't like to do this, but occasionally I do. Would you like me to refer it to the friend of the court for an investigation as to, I mean, I'd be happy to send it for physical, legal, and parenting time, and with that, it always ends up child support because it can change the number of overnights and stuff like that. Would you like that or not? The reason that I don't allot, especially with two attorneys, is because whoever doesn't get the favorable recommendation is going to say they disagree with it. I'm going to set up an evidentiary hearing anyhow, but it sometimes gives me some extra stuff to work with, especially when I work with the attorneys through settlement conference and stuff like that and whatnot. What are your thoughts, Ms. Coletti?
I think a FOC investigation might be helpful to really delve into this and get a recommendation, and then Ms. Smulders and I may be able to work things out.
I think, Ms. Smulders, you already kind of said you weren't going to object to it.
I wouldn't. I would honestly agree. I definitely would agree with Ms. Coletti. I think that I find them to be helpful in terms of whatever side of the table I'm on, right? In order to kind of guide my clients with not only, obviously my advice or take on the situation, but getting a third party then in there to also support whatever, my advice was or, position was. So I think it would be helpful.
What about, can each party pay their $150 for the referral?
Oh, Your Honor, I would ask that you waive the fee for Ms. Mendoza. She is, I'm currently representing her on an ancillary case basis. This was a referral from Administrator Thalhammer. So, she doesn't, I'm,
All right, okay, no, you don't have to go into a whole bunch of things here.
And my client is a veteran. My understanding is he just gets, you know, his check from.
I'll waive the fees.
Okay.
I'll waive, if I'm gonna waive them for one, I'm gonna waive them for two, and Ms. Mendoza doesn't have the ability, and I'll waive them for both. All right, so we are going to have a hearing on legal, physical, and as well as parenting time, see what's appropriate. As far as modifying any parenting time right now, Miss Smulders has just got in the case. I think you could talk to her. I mean, the right now he gets after school till like 8 o'clock or something, but he can't do it.
correct. This isn't the first time he's done this. He's gotten jobs.
I understand.
Right. Okay.
I guess I'm just saying, if you guys want to renotice this because I need to do something about it, that's fine. But the impossibility of him doing it seems like you can figure something out to do. He gets every other weekend, okay? And I'm not going to modify that right now. I've got to have a hearing if I'm going to do much with that, because that would take away basically all his parenting time. So, but as far as the after school and stuff like that, I'm just going to not modify any of that. Have the attorneys talk. If you can come up with an agreement, send it through or something. The reality is that Ms. Smulders, he can't take the child after school. Is that correct?
Well, so I know, I think that's not correct as of my conversation last night. I know he did try to get a new job, which would conflict with those times. However, he, I think, brought that to mom's attention, and there was some communication going on back and forth about that. And he didn't end up taking the job. So
Okay, well,
as it stands right now,
I'm going to tell you this as far as some guidance, all right? Either, because I may modify his parenting time based on that. I'm not going to right now, but either he's going to pick up the child after school or he's not. And if he starts missing, then I'm going to take that away, all right? Because Ms. Mendoza needs some certainty in her life, all right? And I'm not going to make have him say, hey, call today, you go pick up the child, because I don't know what she's supposed to do with her life as far as working and stuff like that. If he's going to not do it and do it every day, then you can get back in front of me, Miss Paletti, with limited notice. All right. And because I'm not going to, he's either going to do it or not do it. And if he comes back one time and says, hey, I've got COVID, or I'm in a car accident and I'm here and can you help me? That's one thing. But I'm not going to accept this stuff where he doesn't, where he, you know, I can't do it today. I can't do it today. He's either going to do it or not do it. I'm not going to change parent. I might change it after the friend of the court. All right.
But,
yes.
I respect your decision. I would ask
agree.
that you reconsider it, because Ms. Mendoza cannot stay on this roller coaster, and it's affecting her job. And
that's what I've said is if he does not do it, all right, you get in touch with my office and I'm going to take it away from him.
So you're saying he gets one more chance?
I guess that's my way of saying it, because I'm not going to make Miss Mendoza on the roller coaster anymore. Miss Smulders, you better tell him that, because if I get word that he's not doing it, all right, every day like he's supposed to, Miss Coletti, you call my office. You get a quick hearing in here. I'll contact Miss Smulders and say, hey, I'm going to waive the 7 days notice to you and stuff. We'll find something really fast and get in here, and I'm going to take it from him.
If he violates the order and keeps the kids overnight during the midweek, Your Honor, would that also be?
If he does that, you are to file a friend of the court violation. All right. That's the way it's got to go. We all do it that way. File a violation. But I've told him, and I've told Ms. Smulders, he doesn't get them overnight. All right. He doesn't even get them Thursday overnight, like he kept telling me on that PPO. That's not what it says in the order. All right. He's either going to play by the order or he's going to suffer.
he gets the weekend overnight though, correct?
Yeah, he gets Friday, Saturday.
Okay, good. Yep.
You get Friday, Saturday. That's not in dispute. He was on here arguing with me and the PPO about how he gets Thursday nights, and I've had him, and you know, you can't, and he does not get them. And I tried to tell him that, okay, but he wasn't going to listen to anybody. He does not get Thursday nights. He will pick up the children from school every day and drop them off wherever we have to do that. If it doesn't occur, you know what I'm going to do.
Yep.
And I'm going to allow Miss Coletti to come in and ask for it on really short notice. I will be in touch with you, Miss Smulders, and we'll do everything I can to make sure you know about it and make sure that you have an opportunity to be heard. But I'm just not going to require this anymore. There's too much, and I just dealt with him on the PPO. He just didn't show up on a PPO violation. He's got a warrant now from him. I'm not going to play games with him.
I will relay that.
Yes. Miss Coletti, anything else?
No, thank you, Your Honor.
I just reconsidered and came up with the same answer. Okay.
Thank you.
But I am going to do my best to protect Miss Mendoza. All right.
I appreciate that.
And I'm not going to whack him unless I need to.
Understood.
All right.
All right. Thank you.
We'll set up the evidentiary hearing. We'll contact both of you. I guess we will do the referral to the friend of the court. I don't know if anything else needs to be done because I'm referring it for parenting time. I don't know if any other order needs to be drafted regarding this.
I don't believe it does.
I don't think so either. All right. So don't worry. Tracy will be doing all the work that you're supposed to be doing.
Thank you, Tracy.
Thank you.
Thank you. Take care, everybody. Have a good weekend.
You too. Bye-bye.
Bye.
Number 9. Hey, this is the best part of the day. Makes me remember the Beatles' White Album. I remember when they showed up on Ed Sullivan for the first time, sitting and watching. My dad said, there'll never be anything. This'll be. Normally it would have been right, but. Yeah.
Hi. Good morning.
Good morning, Miss Garcia.
Yes,
How are you today?
I'm good. You?
Good, thank you. Mr. Gallardo hasn't. Mr. Gonzalez never showed up. Did you give him notice of this?
Yes, I give him notice, but I don't know, maybe because he's at work.
All right, but you mailed this notice to him, looks like on the 20th?
Yes,
Oh, no, you say you hand delivered it to him.
yes, I did.
So he clearly knows about this motion, doesn't he?
Yes.
This is a matter of Garcia Cruz versus Gallardo Gonzalez. This is a motion by the plaintiff regarding ROPA. She said that she has provided a DNA test that obviously the defendant cooperated with, and he was found to not be the father with that. Is that correct, ma'am?
Yes, that's correct.
Ma'am, just for my, to help me a little bit, please raise your right hand. You solemnly swear affirm testimony given in this case will be the truth, whole truth, and nothing but the truth.
Yes.
All right, thank you. You can put it down. You did have a DNA test with the defendant, and it came back, and you're convinced that he is not the biological father. Is that correct?
That's correct.
And has he had, I don't know is it Amy is the child we're talking about?
Yes, Amy.
Has he had any contact? I mean, has he acted as a father towards her at any time?
No.
Was he there at the birth or anything?
No.
Has he had any contact with her?
No.
All right. And he has not approached you and said, gee, I want some parenting time. I want to see my daughter or anything like that, correct?
No.
All right. It appears that Amy, that child, has been born out of wedlock. I do know that you have listed a biological father, Mr. Vasquez.
Yes.
Once we issue this order, are you going to take appropriate steps to make him the legal father?
Yes.
You'll sign an affidavit of parentage or something like that?
Yes.
All right. And he's prepared to be the legal father, I take it?
Yes, he is.
Does he have contact with Amy?
Yes, he does. Actually, he's my partner.
Okay. All right. So he lives there with you?
Yes, he lives with me.
Sees Amy every day?
Yeah. and she cannot live with him without him.
All right, then we'll issue an order that Amy is born out of wedlock. I think this is part of a divorce filing.
Mm-hmm.
Do you have other children?
Yes, Josue, who is 9 years old,
Okay.
and Jaylene, who is 6 years old, and then they are biological to Jose.
Okay, I was just making sure, because otherwise I would change this to a DO divorce, but you still have children. So you can now proceed with your divorce in the timely manner that you can. I don't know if you've been 6 months or whatever. I don't know if there's been an answer, but Amy will be off of the divorce, okay?
Okay.
Part of the divorce, okay?
Okay.
Okay, we'll do that order as soon as we can, okay?
Okay, sounds good.
Thank you. Have a great
Much.
day.
You
Thank
too.
you.
Okay, bye-bye.
Good morning, Your Honor.
Good morning. Ms. Selleck, how are you today?
I'm good. It's been a little, excuse me, it's been a while since I've been in front of you. Good to.
Yes, it has.
Good to work
My
with you all.
loss, not yours. I'm sure you don't mind not appearing in front of me. But, and you.
As
have
you're one of my favorite referees, as you've told all the
Yeah,
attorneys. that.
You probably have told that to every referee you've appeared in front of.
I'll take the, no comment. Is Mr. Silas, or I'm sorry, Mr. Bush here on this?
Haven't seen him.
Oh.
He's the one who filed the motion. I have not seen him log in to, Zoom. Let me call the case, okay? This is S, matter of Higgins versus Bush. We have the plaintiff, Ms. Bush, with her attorney, Ms. Selleck, present. And Mr. Bush, who filed this motion, asking for unsupervised and not at safe connections, and says she cancels visits and all this kind of stuff, has never been on. This was set originally for 8:30, but.
And then 9:30 time block.
And my clerk basically contacts and said, you're in the 9:30 time block. I think you probably got that notice too. It's now 10:35, and he has never logged on. He's not here in the courtroom. Obviously, he's not going to win this motion. You've done a great job, Ms. Selleck. It's rare that I bet you haven't lost one where the other side didn't show up in a long time.
There we go. Would you like me to prepare? Are you denying his motion on the record, Your Honor?
I'm denying it. We're going to do just a quick handwritten one denying his motion. Okay, he failed to appear, and so we're going to deny it.
Thank you, Your
Anything
Honor.
else?
Nothing at all.
Ms. Higgins, you're sitting there quietly. Anything you wanted to say?
No, thank you. Your Honor.
All right, everybody, take care. Have a great weekend.
You
All right,
too, thank you.
Thank you. 760 or 30 DM Ramos versus Ramos. Both parties are present on Zoom. This is a motion that has been filed by father for a parenting time motion. There was a judgment of divorce in 2020 with parenting time in the order. Apparently he gets 2 afternoons and every other weekend. Says he isn't getting his time. He says there's a no contact out there somewhere against him. I'm not sure what that is. And he now wants week on, week off. Ma'am, is there some kind of no contact order?
Currently, no.
Okay. You can get to a place and sit down.
Yep. I'm going to my office right now. Hold on.
So there was a no contact order from March until October 2nd.
Until 2 days ago?
Violence situation. I was charged with it, but that no contact order has been lifted.
Are you charged in like court, like criminal court?
Yes, sir.
Okay, then you shouldn't have had any contact, because any contact you would have would potentially violate your order.
Correct.
You could get locked up.
Correct.
But we had a third party involved. I mean, the children was the no contact order wasn't with the children, and what we had before was every other day and every other weekend.
Did you file any complaints with a friend of the court for not getting your parenting time? Because that's what you have to do.
Well, we opted out of front of the court.
What?
We opted out of the front of the court about 2 years ago, and we had established parenting time at that time. But since the domestic violence situation came up, I haven't been getting the children how I used to get them, every other day and every other weekend.
Is the case still pending, the domestic violence?
No, sir. I've been officially charged with it. I've been sentenced with it already. It's over.
As of Yesterday, correct?
All right.
Tuesday.
Tuesday.
All right. Tuesday, yesterday, whatever. All right. Second. Today's the 4th. All right. So what do you, I mean, you're asking right now for a change in custody because you want to go from every other weekend and 2 evenings a week to 50-50. That's a huge change, and you have to meet Vidvarka to do that. Proper cause or change of circumstance, which there is nothing pled in here that would give me proper cause or change of circumstance to even have a hearing for a change of custody.
But I didn't have them for 2 evenings and every other weekend. It was every other day. So Monday, Wednesday, Friday, and then I would get them that weekend. Then the next week would be Tuesday, Thursday, and then it would be her weekend.
Yep.
Yeah, and we haven't been doing that.
I understand, but you can basically get 52 overnights a year.
It was supposed to be 50-50.
Well, it's not 50-50 because you get some time after work and then you get
correct
that. And trust me, it would be a change of an established custodial environment. You'd need to meet, even if you got to an evidentiary hearing, you'd have to meet the standard of clear and convincing to try and change that. There is nothing here to indicate the fact that you had a domestic violence and had a no contact for a while. Was the victim, who was the victim?
It was Selena.
All right. Well, that's one of the things right in here in the best interest factor is domestic violence. And it's not a good thing. You haven't met what is necessary to meet to get an evidentiary hearing regarding change of custody. You just don't.
Also, Sir Frederick, I did have a few questions about this.
Why? You just won. I given a chance, maybe you don't win?
I'm sorry?
What is the purpose? What do you want to ask? I mean, what's
so during this time, there was no child support, obviously, because we were supposed to do 50-50. So I was gonna ask if we could have that reviewed.
You can go back and ask the friend of the court to get back into this.
I did, and they said that I could ask during this time because I did apply 3 times within the past 6 months, and I got denied because of
denied for what?
Because they said that I needed to go through court to do a review.
Okay, but did you opt back into the friend of the court?
I did, yes.
All right, you've opted back into the friend of the court. This is not a motion that you filed for child support. It's improper notice. He doesn't even have notice of it.
Right. Yep.
I can't grant anything like that right now.
No, I'm not asking. I'm just saying, will there be do you know if I could get a review on that after this or?
Talk to your work at the friend of the court or ask for it somewhere down the road. I can't hear that motion because he doesn't have notice, and I'm not going to make him respond to something he doesn't even have noticed.
Okay, sounds good.
All right.
So moving forward, what will this be?
It's nothing. It's back to whatever it's been. It still stays the same from as far as I know. The friend of the court will now be involved. You can talk to the friend of the court about things. Nothing. He gets his parenting time like he always has. There's nothing changed in the order. He just hasn't met what is necessary to change to 50-50.
Okay.
All right.
So the parenting time has to be enforced now then. So she has to let me get my children every other day and every other
Parenting
weekend.
time always has to be enforced. That's it. Parenting time is always there. If you don't get it, you file a complaint with the friend of the court. They will investigate it. And if they find that she's in contempt or whatever, and if you guys can't agree on something, it'll come in front of me and I'll decide whether somebody's in contempt or not. That's the way it's always been. If she, the orders are the orders. You follow the orders.
So July 2nd, I did send him a suggested parenting schedule, just so that way we could be on board and on the same page.
But you're trying to take
I can't make you guys agree, and I'm not going to do anything on here right now. If you guys want to agree on something, you can agree on something. If you don't, you come to the court. But at this point, he doesn't meet the standard to get his 50-50, and I have nothing in front of me to change any parenting time or whatever. The order is the order. You follow the orders until they're not the orders. So
how do I not meet the qualifications? Like, what do I need to do?
I mean, I don't give advice. I'm telling you, if you don't get the time, go to the friend of the court and file a violation. I've told you that at least 3 times.
So this motion, it just seems this motion really didn't help anybody. It didn't help me. I mean, she's still going to withhold my kids.
It was filed. I followed the law, so that's what had happened. Good luck, everybody. Thank you.
The thing is,
We're
she was holding
adjourned.
my kids. I've been going through this for
We're
months,
adjourned.
and I was told to file a motion, so I did file the motion. So something can happen.
Because you file a motion doesn't mean you win. Jesus. Weider versus Kirkwood. This is a motion filed by the defendant, Ms. Kirkwood, regarding child support. They just entered a order of zero child support because they got 50-50 on 6/17/24 that she agreed to at that time. And now she's asking for child support, even though we're only like 4 months down the road. Ma'am, what has changed since the order was entered?
I didn't have a lawyer at the time, so I didn't understand that that was being put into the order. I had already filed two child support cases.
You signed it.
Yeah, but that's because I thought I had two child support cases that I had already tried to get
Can't help
through
you.
the system. And so this whole time I thought that that was a separate, I guess, order than,
You
because I
signed an
was
order allowing for zero.
yes.
And you're
Like I said,
responsible
I
to do
was
that.
not understand. Yes. I can admit I was not under the correct understanding of that. Because like I said, I had been in contact with the child support office for months at this point. So I figured that was being handled under a different order because I was talking to the child support and they made me call
And there's
another
no
place.
change of circumstance to allow for child support at this time. There's no change in the party's incomes or anything. There's no change in the amount of time that the parties have. I'm not sure if he doesn't have 8 overnights and you 6 overnights, from what it looks like in the order. But the order says you each get 182 and a half. I guess you can file for relief of judgment if you want an appropriate motion like that because of duress or something. I'm not sure you're ever gonna get through that, but that's about the only thing you can do.
Okay, then I will go through that avenue and get that figured out.
You gotta meet some pretty strict standards for that. Mr.
Yeah,
Weider,
but my income has changed and things have been rough throughout the summer. So I think that he should be, considering that he's completely left me with all of our credit card debt, completely screwed me out of our house.
should have figured that out a long time ago. I don't know, it's a DC, you were never married. I don't know how in the heck he, if it was his house, he doesn't, there's nothing there. You don't get part of it unless you're married. This is not a divorce. This is not a divorce. You know,
Okay.
I don't know what, Mr. Weider, was it your house or what?
Yes.
You're not entitled to any part of it, ma'am. It's a
Yeah, it was a
custody
house
matter.
that
It
was
is not a
purchased.
marriage. The court does not divide stuff up per, what you're talking about is a divorce and it just doesn't happen. So, I'm gonna deny your motion. Mr. Weider, I didn't give you a chance to talk other than my one question, but I'm denying your motion. I don't know why you would wanna talk.
Right.
All right, thank you. We're adjourned.
Good morning, Your Honor.
Mr. Judd, good morning to you, and I see you got your client there. Mr. Rummins, turn on your camera and, see you. Mr. Rummins, where's your attorney?
Not sure. I'm trying to turn on the video right now.
You better call your attorney because he's never logged on and it's closing in on 11 o'clock. He should be here.
Okay.
So, mute it. Give him a call, find out where he is. Mr. Judd, I guess you can mute because I gotta try and have him here. He's never logged on and it's closing in on 11 o'clock.
Okay. We'll be here.
And we sent him an email and stuff. We'll see if we can take another one if he logs on, or else we'll put you back in the waiting room. I'll get to you as quick as I can.
Okay.
Maybe you ought to call Mr. Browning and see what the heck's going on.
I'll also give him a call. Thanks.
All right, thank you.
21, just like
Think of what? Never was. Ms. Ochoa, are you there?
Hello?
Hello. Can you hear me?
Sorry, I can't hear you that well, but I'm here.
All right, well, Mr. Williams has never logged on. You have not, you said you mailed this motion to him last Friday, is that correct?
Yep, I paid to have it sent off.
You pay what?
I paid to have it sent off.
But it went out last Friday. That's not sufficient notice for this Friday. And he's not here.
I asked, before I sent it off, I asked the lady on the second floor because the lady on the fifth floor told me that I had to get it to him a different way. So I did send pictures over to one of his relatives of the motion. And then I sent the one out in the mail. I double checked before I sent it, but I still made sure that I sent it via text.
That's fine, but the court rules require that you mail it to him, not last Friday, but you would have had to mail it to him last Wednesday, a week ago. And since he is not here, I cannot hear your case because he does not have sufficient notice.
Okay, so me sending it via text to his brother isn't sufficient.
That's right. That's not sufficient. You have to give him notice according to the court rules and either hand it to him a week in advance or mail it to him 9 days in advance and provide proof of service of when it is done. I was hoping he'd be here and we'd deal with it, but since he's not, he doesn't have sufficient notice and I can't deal with it. So you'll have to renotice it for some time in the future. All right?
I mean, if we renotice it, he's not going to show up regardless. So, I mean.
I understand, but you gotta understand, I gotta follow the law.
Yeah.
All right, so.
So I sat on here for 2 hours for no reason.
That's right. No, not for no reason, it's because you didn't follow the law. Thank you.
Well, I asked one of your clerks and that's what she told me, so I don't know.
Okay.
Oh.
The clerk is not the judge, the clerk does not know law.
Oh, okay, well, since you don't care, there's nothing.
Thank you, we're adjourned. You see, the court sent her notice about all the mess ups that she'd done. She'd set it for 1/4/24 or 9/16, all of which were past the time.
This one might be the same deal. We have, defendant, John Danian.
John Danian's here. John Danian, but not Renee Wagner. Well, we'll find out. You know, Mr. Danian, this is a motion apparently filed by you.
Yes. Just a very straightforward motion just to come get her stuff.
Renee Wagner was on this, I thought. Have you had any contact with her or anything?
I did. She said that her client had no interest in the property. The only problem is that I think it's some pretty heavy furniture and things, and my client feels that these are items that they kind of fought for in the divorce, and she wanted them, and now he's going to have to either hire someone or pay to get them out of his house, and he feels that she should be responsible for the disposal if she doesn't want them.
What? All right, this is case number. So Miss Wagner is not even going to show up. Nobody's going to show up.
That I don't know. They may not. She may not have been paid to, because the divorce released the attorneys, and so I gave her a courtesy copy of the motion, and I know that her client had received it as well. But then I didn't know if they were challenging us or just wanted to.
As long as you gave sufficient notice to the plaintiff, and you gave a courtesy copy to Miss Wagner.
Correct.
They have notice for this hearing, right?
That is correct.
All right. This case, I haven't a prayer of figuring out how to pronounce that last name. I'll leave that up to you, Mr. Danian.
Okay. And I'm not going to do much better. Tazdowski. Brian, are you there?
You're on here, Brian. If you can unmute, this is Tazdowski versus Tazdowski. We have the defendant who is present with his attorney, Mr. Danian. This is their motion regarding enforcement of a judgment of divorce. And basically you're saying that she was given certain items in the divorce, but has not picked them up. Is that correct?
That's correct. Yep.
And so, what, they're in his house or something?
They're in his house, and he wants to rent out, at least one of the rooms that these items are in. My understanding is that some of them are large items of furniture that he cannot easily move himself. And he doesn't feel like he should be responsible for, moving those or having someone move them or dispose of them.
Well, I mean, I've got a list here. What's the things that he's?
Brian, can you unmute?
Most of these are food processors and.
It's the furniture, the big furniture items.
Fishing poles, telescope, sandals, shot glasses, dolls, turkey. I'm looking for something that's under movies.
He sent me pictures in his house of a couple items of like furniture.
I don't see any listed on here.
Brian?
Yeah.
Tell the referee what items that you are still there that are the big items.
Well, we went to a meeting, which I had to pay to get her stuff out of here, and she agreed to it. I got a piece of paper that says that she's supposed to get all her old or her original furniture out of here.
I don't have that in here.
You don't have that paper?
Well, I've got a list of items, none of which are furniture.
Well, the mediator wrote on the paper saying that she's supposed to get all her premarital furniture out. And I signed the paper. And she signed the paper.
I can only deal with court orders. Defendant is awarded property in the marital home, except as specified herein. Plaintiff is awarded the following, movies, CDs. There is a maroon colored lazy boy recliner. Medicine, fishing poles, telescopes, sandals, shot glasses, food products.
She got all that stuff.
Small grandfather clock. Well, I don't see anything else in here.
I'm going to double check real quick as well, Your Honor. Are you looking at the judgment of divorce?
Yes. Page 2, personal property. And now he says she got all that kind of stuff anyhow. The movies and the sandals and the shot glasses and the dolls in protection from Germany, from Army, turkey platter, Corningware, food processor. I don't see, the only thing that is anything is a lazy boy recliner. Did you get that?
Yeah, she got all that stuff. But there's still some of her everything. She's got everything that's on that list, but right on the bottom, when we went to this mediator.
Don't care, it's not in a court order.
Oh, it's not in the court order?
No.
Well,
I'm looking, Judge, under personal property on page 2.
Yeah.
The second or right before the last sentence, and any premarital furniture.
Well, I don't know what the premarital defendant is awarded all property in the home except specified below. Personal property.
The second to last sentence, grandfather clock, assorted vases, and any premarital furniture.
Okay.
I think that's what he's referring to.
Right.
If she didn't pick it up, you can get rid of it. You can sell it on eBay and it's yours. Anything that she has not picked up, and she's saying she's not going to pick anything up. So anything that she has not picked up by 1 week from now is yours. You can sell it, do whatever you want with it.
And then if he incurs any cost in having it disposed of?
I'm not, I don't even know how much it is or what. I mean, what is, it's furniture. He can keep it. He can use it.
Okay.
It's his. If she doesn't pick it up, it's his.
Okay.
Okay. Put an order that she has 7 days from today's date to pick it up. Well, I better make it 14 because otherwise we'll never get it to her fast enough.
Oh, correct.
And after that, end of story. Why don't, and Mr. Danian, I know I really trust you. I think you're a good guy. Okay. And I would like you to call Miss Wagner and just tell her that?
Sure.
14 days in case she wants to pick up any of that stuff. Otherwise, it becomes Brian's things.
Okay, absolutely.
Right?
Yep.
Good luck. Thank you.
Thanks, Judge.
It is the matter of Ramos versus Cabbat. We have both parties present. We also have Mr. Browning on behalf of Mr. Ramos, and we have Mr. Judd on behalf of Miss Cabot. This is Dad's motion for custody, temporary, whatever it may be, and he starts out with something that is a blatant lie to the court when it says there is no prior order regarding custody. There is a judgment of custody from 7/28/20 that gives mom sole legal and physical. Why would you allege that in your pleading that there is no order? Mr. Brown.
That's what I was told by Mr. Ramos.
Did you look at the file?
No, we didn't do that.
I mean, the motion becomes frivolous, basically, and I don't know why I wouldn't award some costs, because she's already got physical custody. And he wants temporary. He doesn't get it. It states in there what it is. Because mom left the kids with a boyfriend instead of not going, I mean, it doesn't form anywhere near Vadvarka. What? Go ahead, Mr. Browning. Tell me why I shouldn't issue some kind of cost to Mr. Judd on this.
Well, thank you, Your Honor. Supposing we hadn't misstated that, it would still be appropriate to revisit this issue because he essentially has no parenting time. There is an order that's only from 4 years ago, and they did attempt mediation over the summer and it was not fruitful. They went to mediation on July 9th. So other than misstating that, his
Other
motion.
than misstating that, you're asking for temporary custody for him and stuff like that. Because there is no order, and it is clearly wrong. You're asking for temporary custody in your request, in your motion, and even in your wherefore. Temporary grant him custody of the minor children until a hearing can be had regarding the children's best interest. Why would I even consider that? There's nothing of Vadvarka in here. Nothing. Mr. Judd?
I don't have anything to add to that. Certainly, I'm in full agreement.
What the heck?
I mean,
Your Honor, I guess the only thing I would add is it isn't like Mr. Ramos doesn't have any time. They agreed on these alternate weekends and the Wednesday evening.
That's what I understand.
Okay.
I mean, it seems that he has time. He's asking for a change of custody. Mr. Browning, you're asking for temporary custody in your pleadings.
This is not good.
And Mr. Rummans, you knew the order was out there that she has sole legal and physical custody. I don't know why you you signed this just like he did.
I was going for 50-50 custody was the beginning process.
Yeah, but you know she has legal and physical custody from 4 years ago, and you have nothing to make a request based on. 50-50.
I have changed my whole life to be
For what? You got to provide something, it's called Vadvarka, proper cause or change of circumstance. Just because you're doing better in your life, that doesn't affect the kids.
I changed my address. I take my kids to church as much as I can. I do everything I can for my kids. I believe
it doesn't provide Vadvarka.
I believe it's in best interest for both parents to be equal parenting.
For you, it doesn't provide anything for a change of custody to the court. No factual basis for a change of custody, and you put in your thing that she does not have custody and that there's no custody order. That's misleading to me. I had to go through and find it, or Mr. Judd had to tell me. Mr. Judd, are you seeking any costs for this?
I am. Obviously, this should not have been brought. We made it very clear in our response that it shouldn't have. So I would like to have costs.
Well,
I also don't mind entering an order pursuant to what the parties are doing.
That's fine. Talk to Mr. Browning and enter an order that he gets every other weekend and Wednesday night or something like that. I don't care what you guys agree to.
I understand.
All right, I don't care what you guys agree to. I'm not going to interfere in that part of life. And it appears that he gets every other weekend from such and such, I don't know, from Friday to Sunday.
Yeah.
One night a week.
Your Honor, she says that I get every other weekend, but she also doesn't allow it certain times whenever it's best for her.
You don't have an order for it right now. Anytime you get is lucky for you. How would you like me to read some of the texts you send to her?
Them are way back when we broke up. If they were, I don't even have that.
Are any of those, can you tell me when some of these texts are from? Like the completely inappropriate, you're a piece of shit. Piece of shit. I can quote from here.
But
some of these things.
You
being a piece of shit is where you want to be. How many times she call you that? She didn't in here.
But
it's the way you obviously want to be addressed.
Well, Your Honor, I spoke about these texts with my client after we received their response, and he says they are several years old.
Mr. Judd?
They're from July.
No, they're not.
All right, do you want to have a hearing on that? And I'll tell you what, if she can show me they're from July, I'm going to burn you big time. I'm going to make you pay for the whole hearings and everything.
They're not from this July.
Are they from this July, Mr. Judd?
No.
I'm looking to see if there's anything on the text.
I don't see any dates on it, and I'm not going to deal with it anymore.
Sure.
I'm telling you.
Says August 19th.
August 19th of what?
June 10th is on another one.
They're not from this year.
Okay. I don't want to spend time having a hearing on that.
I don't want to spend time on it either. I want to make a point that it's time that you grow up and quit sending that kind of stuff. I don't care if they're from last year. It's completely inappropriate. Completely. Don't argue. There's nothing of value in that kind of stuff. The way you address your child's mother.
I agree.
Mr. Judd, what are you seeking? I'm not going to give you a lot of attorney's fees, but what are you seeking? And if Mr. Browning objects to it, we'll have to have an evidentiary hearing on it.
I think fees of let me look real quick.
What do you charge an hour?
$750.
You don't charge $750 an hour. How much do you charge?
Oh no, I'm sorry. That's what I think would be reasonable.
How much do you charge an hour?
$450.
All right, and you're saying what, an hour that you did, or I don't know what it is.
Yeah, I think a couple hours would be appropriate.
Mr. Browning, I'm not going to give him $450 an hour. I'm going to give him $350 an hour, $300 an hour. And I'm going to give him 2 hours unless you object to it, in which case we'll have a hearing. But if you lose, then you have to pay for that whole hearing also.
Your Honor, were you planning to formalize the alternate weekends and the Wednesdays today?
You guys can, if you guys have an agreement, we'll put it on the record right now. You have an agreement that every other weekend?
To that, I think I put that in my response.
Yeah. What is the day, the times?
So
every other weekend, Friday at
what time? Friday at 5 until Sunday at 5?
Friday at 6 on a regular.
They do 6 regularly.
Friday at 6 to Sunday at 6?
Yes.
Yeah. We'll put that by stipulation of the parties. Do the parties stipulate to that?
Can I get more time, please?
No, you don't meet the standard for it. She's offering you that if you want to fight and you want to have a parenting time hearing, we can have a parenting time hearing.
I thought that
You're not going to get 50-50 because you don't meet the standard.
is there some kind of book that I can get that says the standards?
You got an attorney. I'm not going to give you advice. I'm going to tell you it's denied what you asked for today. And I find it to be offensively frivolous because you didn't even say that you have a custody order when in fact you did. Now they're offering, if you don't want any, if he doesn't want that order, then there's nothing to enforce.
Okay,
You don't want that order?
I do.
So every other Friday at 6 till Sunday at 6, and every Wednesday from what till what?
5 to 8, if we could.
From 5 till 8, just like you've been doing. You can enter that stipulated order, get it between you. Now, Mr. Browning, are you objecting to the $600 and you want to have a hearing, or because I'm not giving him his full rate, and obviously he's been on for a while and had to file this. 2 hours is not an unreasonable time. Your choice.
If you're holding that this was frivolous, then I think 600 is a fair.
All right. You may also include that in the order.
What should be the time frame on the $600?
Month.
Okay, will do.
Good luck. Thank you, everybody. We're adjourned. You'll